Here's a couple of random nuancy or just extra little tidbits. So the first one I have on here is gross negligence. So sometimes a director, it can be held, or they might accuse a director that they potentially acted grossly negligent regarding a business decision. And how that's determined is if a director made a decision and they did not get adequate information, they fail to inform themselves of any material information that is or would have been reasonable for them to have known or figured out. So, like if they want to buy a piece of property and they didn't bother to look at other properties in the area or do any research about the property or didn't do any title checks on the property they did end up buying, that would be grossly negligent in their conduct regarding a business decision because they didn't inform themselves, they didn't take it upon themselves to do anything that would have allowed them to get this information they should have gotten or searched out or sought out, if you will. So that's how that works. So gross negligence is something that you can have breached. And if you do breach a duty, they say the duty that you breached was care because you were grossly negligent. The BJR rule, so business judgment rule, would not protect you in that situation. A very, very common thing that comes up is called de facto corporation. That can be applied to a partnership, an agency, de facto agency, de facto LLC, de facto corporation, de facto partnership. And what that means is even if you didn't go through the right steps to create a corporation or partnership or agency at all, the court will pretty much treat it like it is a partnership, a corporation, LLC, even if it's not, even if the proper channels weren't followed. And the reason why they do that is because in fairness, it ought to be treated that way, and for justice to prevent an unjust result for somebody else if we do not treat them like a corporation. And sometimes if we are not a third party, say that we're a part of the corporation, we're being sued personally, we're going to say we should not be sued personally. That corporation should be treated like a corporation because of these reasons. So de facto corporation can be applied either because of a third party that was harmed or because of somebody a part of the corporation that's trying to get away from liability. If it's the latter, then you're going to look at, okay, did this person act in good faith reliance, believing that they thought that they were an established corporation, they thought they did everything they needed to do, they did file paperwork, and they did everything that was required of them or whatever. So usually that this can happen if like there was a filing error or something happened. Or that they, were misinformed and they filed the wrong things or didn't file anything at all. You can potentially be found to be held liable if you didn't file the proper actions because you were negligent, you didn't want to get, information, you didn't want to pay for an attorney, you didn't look into that. They might say you're going to be held personally liable because you obviously didn't put in enough effort, you didn't put in a good faith effort. But if you got an attorney and they told you to do X, Y, and Z and you did those things, you probably thought, and you were acting on the reliance that you thought you had a corporation, did everything you could. So we're going to say de facto corporation. On the other hand, we have a third party who says, I thought they were a corporation. I acted on reliance that they were a corporation. They weren't. The court might hold them to be a corporation to be able to help prevent any type of fraud or injustice that would occur because of that. So de facto corporation is just merely when a court pretty much makes a business the corporation that they claim that they were or that people thought that they were in order to ensure a good remedy. Waste is something that can allow you as a shareholder or a plaintiff to argue that a corporation did not act within the best way regarding decisions for a business. Or it could be applied to other things, but it's most common in corporations. And really the doctrine of waste is really a decision that was made for a business was something that a reasonable person in their right mind would not do. Like there's nobody that would say that's a good idea. So because of that, they committed waste. And committing waste is also some way to get out of the business judgment rule because it shows that you did not do what you were supposed to do. You did not act diligently. You didn't care about the organization. You were not acting under your fiduciary duties at all, and you harmed the business because a reasonable person would have not done it in a million years. The fact that you thought it was okay doesn't make any sense. Kind of to go off of that, you have estoppel. I put depends on there. So estoppel is where the court will literally stop you from arguing that you are a corporation or that you're not a corporation or that there is a partnership or there's not, or there is an agency relationship or there's not. So it can literally prevent you from claiming something or prevent somebody else from claiming something against you. So the term estoppel can be put in so many different things because it's a very, flexible term. So if somebody says that, say they sue you under, uh, agency principle doctrine because your agent got in a contract with a third party that you did not authorize, and you're saying, I had no relationship with this person, but let's just say like you were negligent in your words and conduct, you made it appear that he had the authority to act, you gave him apparent authority, then the court's going to stop you from arguing that there was no agency relationship because obviously there was, or you made it seem like there was because of your negligence. Or on the other hand, if an agent's running around saying, I have authority to do these things, and they don't, and said that they used to work for the principal, but they don't anymore, and the principal filed something, with the state, or he sent a notice out to all of his contractors, or he put it on the bulletin. He did everything he could to make sure everybody knew this guy didn't work for him anymore. It's been years. 3 years later, somebody's suing over this contract that he made. Well, the third party is going to be stopped from asserting that there's a relationship here because the principal did everything he could. And there is a doctrine that says that even if somebody no longer is an agent or an employee of someone, they can still have lingering effects for up to 2 years. And it's been 3 years. Obviously, it's been long enough, right? So we're going to stop them from doing that. So estoppel can be, applied either way. You're going to see quorum a lot depending on what type of business. So quorum has to do with the majority of who's there. So if I have 15 people here and 9 people voted in favor of this business decision, then I have a quorum vote. I have a majority. Now, quorums can get confusing because sometimes you have different types of voters. You have people that have a heavier vote. You have the people that are required to get a vote. That's their right. You have people that are not required to get a vote, but may get a vote. So sometimes they might say the quorum of the majority of the majority stockholder, or the quorum of the outstanding stock for X and Y corporation. So it can get very confusing, but really just look at if there's a majority of the people that showed up, unless it specifically says in the fact pattern that they were missing people that were completely entitled to a vote, then you're fine to just assume if you have a majority, then you have a quorum, you can move on. You have a lot of phrases that are thrown around, dividend and distribution. Dividend is typically amount of money that's given to a shareholder. Now remember, a stock or a bond is an equity interest in a corporation, and you are paid as a bondholder or a stockholder depending on the terms of that stock that you purchase or that bond. And the amount you're paid usually has to do with the profits made throughout the year, absent expenses. And so the amount that is paid to you is called a dividend. So think of it like they divide the total value based on the total shareholders, and they give you that value and what is called a dividend. And then you have obviously what's called distribution. So that could be one of two things. A distribution can be the withdrawal of funds from a business or a partnership. So withdrawal of funds could simply just be, you're taking money out of the partnership for yourself for livelihood, say $2,000 that you take out, you withdraw that could be called a distribution. Or when you get a business completely disillusioned, a business is completely canceled, closed, they go bankrupt, whatever, the court says they have to wind up the business, and there's $50,000 left, and there's 2 partners, they could get a distribution of $25,000 each. So distribution is either money that's coming out or money that's given because something's ending. It's just literally they're distributing funds. And then obviously the last one is buyout. A buyout is usually for minority shareholders. Sometimes it could be for partners or members of an LLC if they want to get rid of them. It has to usually be in the articles of incorporation if it has to do with stockholders, or it should be in the operating agreement or partnership agreement. It can be in the bylaws, but very rarely, because typically the AIC, the Articles of Incorporation, discusses more in depth of what happens when there's a problem with shareholders. Bylaws is more so like how we're going to operate the business, but it could be something in a bylaw potentially about it. The point is the bylaw or the buyout is supposed to give an out for minority shareholders that are being frozen out, overseen, or are mismanaged, or there's some type of abuse because they're not getting the value of their share because they're a minority shareholder or they're trying to take advantage of that. So if there is a buyout agreement, look to see that where the agreement was placed. Was it articles of incorporation? Was it in a bylaw? Was it in an operating agreement? And based on that, does it say anything about how the buyout's supposed to occur or when somebody's entitled to a buyout? And then if they do end up doing a buyout, and if they say it was all up to snuff, they don't give a lot of facts, you just assume it is, then you have to look to how is the buyout actually performed. You can look and see if there was an independent appraisal. If there was an independent appraisal on the stock value, then that could go towards the fact that it was a totally fine buyout. It's very fair. If there's nothing that discusses that, then you can say, okay, well, although there is a buyout agreement, it wasn't done fairly. Or there was no buyout agreement, but assuming that there should have been one, it should have been conducted this way. So that kind of goes towards the process of how a buyout occurred. But that's kind of like a term that comes up if you have issues with stockholders or minority shareholders or minority members or people that are just not getting their full due or their rights, or they're easily kind of like ignored or trampled over, if you will, because they just don't have enough interest or value of the share of the corporation or value within the actual LLC or whatever it is to be listened to or heard or to have any type of say. So always look towards that. Most time if you have an issue, it's going to be what's called frozen out because they're trying to do some type of changeover or merger, or sometimes they have hostile acquisitions. The whole point is they're trying to take advantage of a minority shareholder's position to benefit themselves as opposed to benefiting every shareholder. And if they have those issues, the shareholder's going to be like, well, if I don't like this, I can just leave, or I want to leave. And if they're a minority shareholder in a public company, they're going to say, well, then you should just leave. Nobody's stopping you, but they want to get their money back. But you usually have buyout issues when you have partnerships, LLCs, or a closed corporation. Yep, I think that's about it.